Hi guys, welcome to another discussion, that is Indian legal system. This is indeed a very essential topic, that is we will be discussing on various responsibilities of a doctor, various legal responsibilities of a doctor, the procedures, the proceedings in the court of law. You can see the conduct of a doctor in the court of law. So everything will be discussing in this Indian legal system. Forensic medicine is the only subject where we'll be discussing about all these court procedures and everything. This knowledge on this particular topic, this is indeed very important for a doctor who's practicing. Okay, so let's start with Indian legal system. To start with, let us start with certain basic definition, very basic definition, that is the definition of forensic medicine. What is basically forensic medicine? This is the application of medical knowledge. Whatever medical knowledge that you've got, you're applying it for legal purposes so that it will help in the administration of justice, right? To help in the administration of justice, you are using your medical knowledge to help in the legal proceedings. That is called forensic medicine. Then we have medical jurisprudence. What is medical jurisprudence? See, jurisprudence, prudentia means knowledge, juris means law. So it's basically the application of knowledge of law in the practice of medicine, right? So basically it is about the legal responsibilities of a doctor and the medical profession. Fine. It's the application of knowledge of law in the practice of medicine. Then we have one more very important definition. This definition is important for examination purpose as well. So medical ethics. This is not only for examination purpose. This is also important for your medical practice. If you're a doctor, you should have some medical ethics. You should know some moral principles and you should abide to the ethics, right? So what is basically medical ethics? It is a set of moral principles, right? It is a set of moral principles which guides the members in the medical profession, which guides the doctors basically. It guides the members of the medical profession in dealing with each other, that is doctor to doctor relationship, in dealing with the patient, doctor-patient relationship, and in dealing with the doctor-society or doctor-state relationship, right? Doctor-doctor, doctor-patient, doctor-state, all relationship, you need to have some moral, you need to follow some moral principles. That is called medical ethics, right? That is called medical ethics. It's basically self-imposed, right? The doctors voluntarily impose these kind of medical ethics, right? It is framed by NMC. Earlier it was MCA, now it is NMC. But do remember, any violation is punishable, right? Unethical act done by a doctor, it can be punishable. Violation is punishable. So this is medical ethics. We have one more similar definition, that is called etiquette. What is this medical etiquette? This is basically the law courtesy. It is a courtesy which you extend among your fellow colleagues. That is basically your doctors, right? Conventional laws of courtesy between the doctors, in between the colleagues. But here it is not compulsory. Violation is not punishable, but ethics violation is punishable. It is compulsory. Every doctor should follow these moral principles while you are practicing medical profession. We'll be discussing in detail about all these things. So let's start with that. Before learning about Indian legal system, I'll tell you another important basic things. Right? So to start with, we'll start with what is called as IPC. What is basically IPC? IPC means Indian Penal Code. Indian Penal Code. Underline the word penal. The word penal, it means penalty. That's basically, it's about punishment. So this is a code. This is a code that will give definition of an offense. It defines offenses. It defines offenses. It also gives punishment for the offense. It prescribes punishments, right? So you will have one section for the definition of an offense. You will have another section that will give us the punishment for an offense. Usually what happens, you take rape, 375 gives you the definition, 376 gives you a punishment. Not always. Sometimes there can be one section which can give both definition and punishment itself, right? 354, A, B, C, D, all these sections will define and punishes. You have a lot of examples for that. But do remember, IPC is the code that is about defining an offense. It tells you what is murder. It also tells you what is the punishment for somebody committing murder, right? It tells you what is an offense. It tells you punishment for an offense. That is IPC. It has got 511 sections, right? It has got 511 sections. Indian Penal Code was enacted in the year 1860, right? British people. Now we have one more important code, that is CRPC. This is again indeed very important. This is Criminal Procedure Code. This is called Criminal Procedure Code. Underline the word procedure. So this is basically the different procedures which you follow in case of a crime. For example, how do you conduct inquest? How do you conduct inquest? How would you arrest a person? right? How do you how do you collect evidences from the scene of crime? How do you conduct trial in the court of law? How do you find out whether the person is guilty or not? How do you give punishment for the person who is guilty? So all these procedures are detailed in this Criminal Procedure Code. It is 1973. Right, 1861, it was amended in 1973. Okay, so this is Criminal Procedure Code, which has got 484 sections are there. 484 sections are there. Now we have one more important code for us discussion, that is Indian Evidence Act. As the name implies, it is all about evidence. Right, it tells you what is the relevance of evidence, each evidence, what is the admissibility of this evidence in the court of law, what is the procedure in recording evidence in the court of law. So all these principles are given under Indian Evidence Act. You can underline the word evidence. That will give you an idea that it is about all evidences, right? And here we'll be having around 167 section. It was enacted in the year 1872, right? 1872. Not so important. The sections are not so important. Number of sections 511, 484, 167. This is it's very, very, very rarely asked. It is not usually asked. It's a very tough question. Unless and until the question paper center does not want any student to answer, they can set this kind of very tough question. Okay, so don't worry. Just know what is IPC, what is CRPC, and what is IEA. That's what you need to know. So let us learn certain basic concepts in the law. Right. So first one, let's talk about what is the difference between a civil case and a criminal case. What is a civil case and what is a criminal case? Do remember, civil case is something between two parties. It's a dispute between two parties. Dispute between two parties. Right? It's a civil case. Right? Maybe it's a divorce case. It's a medical negligence case where the patient is alleging some negligence and is demanding compensation from the doctor. Right? All these are civil cases. Right? Here, the dispute is between two parties. So, in the court of law, it is the plaintiff versus defendant. Who's a plaintiff? Plaintiff is the person who files a case. Right? It is a plaintiff versus defendant. Defendant is a person who's going to defend himself. Right? But if it is criminal case is something where it is illegal, broken the law. Right? The person is stabbed, the victim. The victim was murdered, rape, robbery. All these are illegal. These are the offences against the state. These are the offences against the state. Even though victim is one particular person, even though one person was stabbed, right? The person died, or the person was stabbed, the person got injury, even though that person happens to be the victim, but this offence is considered the offence against the state, wherein the victim will not come here, the state, the government will come in the place of the victim. It is a dispute. Here the case is between prosecution. Here it is a case between prosecution and the defendant, or you can say accused. Right? Why the state has to come in that place? Why the government has to come in the place of the victim? Because it is the duty of the custodian to safeguard the rights of its citizens. Who's a citizen? Victim is a citizen. Who's a custodian? Government is a custodian. It is a duty of the government to safeguard the rights of the victim. And that's why the government will come in the place of the victim, and that is the same reason why it is a prosecution versus defendant. I hope you need to understand it properly. You can see this here, it is a plaintiff versus defendant. Here it is a prosecution versus defendant. Right? Prosecution, that is a state, the government. Right? That is the reason why if you look at this prosecution versus defendant, the government will appoint a lawyer, public prosecutor versus defense lawyer. Defense lawyer is the lawyer appointed by the accused, defendant. Right? Public prosecutor versus defense lawyer. Fine. Now, when you look at this case, in a civil case, the burden of proof. What is the burden of proof? Who has to prove the case? Who has to prove the case? The burden of proof in a civil case, it always lies on the plaintiff. Right? The plaintiff has to produce strong evidences to prove his case. Right? The plaintiff has to produce strong evidences to prove the case. Fine? Right? But in case of criminal case, In case of criminal case, the burden of proof does not lie on the victim. The burden of proof does not lie on the defendant, because it is basically between prosecution and the defendant. The burden of proof here lies on the prosecution side. The prosecution has to prove the case beyond reasonable doubt. That is so important, right? Beyond reasonable doubt. Then only the case will be proved. Beyond reasonable doubt. Whereas in case of civil case, evidences is sufficient. Whereas in criminal case, you need to prove it beyond reasonable doubt. Even if there is any doubt, the case will be, the accused will be released, acquitted. Fine? Beyond reasonable doubt. And if this case is proved, what is the punishment in case of a civil case? In case of civil case, the punishment is only compensation, monetary compensation. The patient is demanding monetary compensation from the doctor. If the case is proved, the doctor has to pay compensation. Compensation. It's monetary compensation, basically. But if it is civil case, it is compensation that is accepted. But if it's criminal case, I told you that is something illegal. It is something illegal where the punishment is not fine, punishment is not compensation. It can be a fine or it can be imprisonment. It can be imprisonment, jail imprisonment. Okay? So that is the basic difference between a civil case and a criminal case. I told you civil case is something between two parties, whereas criminal case is between prosecution and the defendant. Right? Whereas in civil case, the punishment is only monetary compensation, whereas in case of criminal case, it is the fine or it is imprisonment. Fine will be imposed on the accused or the accused will be imprisoned. Jail imprisonment will be done. Fine? Right? So let us learn about some other important definition. What is a cognizable offense? What is non-cognizable offense? Cognizable offense is an offense where the police officer can arrest an accused without arrest warrant. You don't need to have any arrest warrant. Right? If the offense is cognizable. Non-cognizable offense is an offense where police needs to have arrest warrant. He cannot arrest without arrest warrant. Right? Only when you have arrest warrant, you can arrest. Otherwise, you cannot arrest. So which is more serious? Cognizable offense is more serious. Cognizable offense is given by 2C CRPC, whereas non-cognizable offense is given by 2L CRPC. 2L CRPC. What are the examples of cognizable? You can say anything. You can say murder. You can say dowry death. Dowry death. Can say robbery, rape. Okay? You can say ragging death. Right? All these are serious offenses. All these are cognizable offenses. All these are cognizable offenses. Non-cognizable offenses, you can say simple hurt. Voluntarily causing hurt. Simple hurt. Right? All these are defamation. All these are non-cognizable offenses. Where only when you have arrest warrant, you can arrest the person. So we have summons case and we also have warrant case. What is a summons case and what is a warrant case? First, let me tell you what is warrant case. See, warrant case is a case that is related to an offense for which the punishment is more than 2 years. Or life imprisonment, or it is death sentence. Right? When it is obviously more than 2 years, death sentence, life imprisonment is more serious than that. Right? So for any offense, if the punishment is more than 2 years, that case will be called as warrant case. Anything other than that, you can call it a summons case. That means literally, you can say it is less than 2 years, that is called summons case. Right? More than 2 years warrant case, less than 2 years, that is called summons case. Then we have bailable and non-bailable. What's the difference between bailable and non-bailable? It's very simple. From the name itself, you can understand. Bailable offense is an offense where the bail can be granted by the law. Bail will be given for that particular offense. The court can also refuse bail. But non-bailable offense is a very serious offense. Bail cannot be granted. It cannot be granted. Only the judicial magistrate has to decide whether bail can be given or not. That is non-bailable offense. When the bail can be given, that is called bailable offense. When the bail cannot be given, that is called non-bailable offense. Right? So these are the basic terminologies that we have to know. Right? There is one more important concept that we have to know, that is called judicial magistrate. Right? So we have two important type of magistrate. One is judicial magistrate. Another one is executive magistrate. Judicial magistrate and executive magistrate. Judicial and executive magistrate. Right? From the name itself, you can understand. See, judicial, underline the word judicial. They are a part of judiciary. Executive, they are a part of administration. They are part of administration. Their primary role is not for judiciary, right? What is judicial magistrate? For example, you can say it is chief judicial magistrate, right? The first class judicial magistrate, right? Or you can say second class judicial magistrate. All these magistrate will be judicial magistrate. Executive magistrate, you can say district magistrate, additional district magistrate, subdivisional magistrate, right? You can say district collector, tahsildar, RDO. All these people will be appointed as executive magistrate. Fine. Now, who will appoint? That is more important. If you talk about judicial magistrate will be appointed by the High Court, right? They have a degree of law. They are appointed by the High Court. They are appointed by the High Court, wherein their function. See, there I told you they are a part of judiciary. They are a part of judiciary. Their prime role will be to conduct trial in the court of law, right? They are meant to conduct trial in the court of law. That is the primary work of judicial magistrate. They are a part of judiciary. They will conduct trial in the court of law. They will give judgment. So that is basically judicial magistrate. Executive magistrate, I told you, they are a part of administration. They are not appointed by the High Court. They are appointed by the state government. Right? The state government will appoint the executive magistrate, and these people, they are a part of administration. Right? They are a part of administration. They will not conduct trial in the court of law. Their primary job, the primary role is to maintain law and order in the society. Law and order in the society. L&O in the society. Right? So that is executive magistrate. So basically, you know the difference between judicial magistrate and executive magistrate. That is very, very important. Who's superior? Who's more powerful? Judicial magistrate is superior. Okay, they are part of judiciary. They conduct trial. They give judgment in the cases. So let's start with one more important topic. Okay, so that is again very important for your examination purpose, right? You got questions from this particular topic very, very often. So that is nothing but inquest, right? What is an inquest? The literal meaning of inquest is to seek, right? Is to seek. Basically, it is inquiry. When you are doing inquiry, it's called as inquest, right? When you are doing inquiry, it is called as inquest. But here in this context, what we are learning is it is the inquiry into the cause of unnatural death, right? Here in this discussion related to this context, we are discussing inquest. Inquest is basically inquiry into the cause of unnatural death. What are the different types of inquest we have got, right? What are the different types of inquest we have got? We can say we have police inquest, magistrate inquest, coroner inquest, right? Medical examiner system and procurator fiscal system. So you have lot of types of inquest available throughout the world, right? You can see police inquest, very commonly done in India. Here in police inquest is done in India, right? Magistrate inquest also it is practiced in India. Coroner inquest, we were practicing this in India, but now it is abolished, right? It is abolished from Mumbai in 1999. Doesn't matter, just know it was abolished. We don't have coroner system in India right now. In India, we have only two, that is police, another one is magistrate. Then we have got medical examiner system. Medical examiner system, see the medical examiner. This system is a doctor will be appointed as medical examiner, and this happens to be the most superior form of inquest in the world. It's a superior type. Because a doctor himself will go to the scene of crime, he will assist the recovery of the evidences, he will assist the police in investigation, everything. This is the most superior type of inquest available throughout the world. It is not done in India, it is done in certain states of US. Right? Medical examiner system, medical examiner, the doctor himself will be a medical examiner who will who will assist in the investigation process. Right? Then we have procurator fiscal system. Here the procurator fiscal will be having investigations, and it is followed in Scotland. And it is followed in Scotland. Right? So these are the different types of inquest system available now, and out of which two systems are practiced in India. Number one, we have in police inquest. Another one, we have got magistrate inquest. So let us discuss about the police and magistrate system of inquest. Let's say police inquest. right? Police inquest. The police inquest, and I told you, as I told you, we have got magistrate inquest as well. Police is conducting inquest, that is called police inquest. Magistrate is conducting inquest, that is called magistrate inquest. But I told you, magistrate inquest, we have two type of magistrate. One is judicial magistrate. I told you that. One is judicial magistrate, another one is executive magistrate. When these people conduct inquest, we call it as magistrate inquest. Right? Very simple. Now, see, police inquest is the most commonly conducted practice system in India. It is the most common type of inquest practice in India. Right? Whereas, which is superior? The magistrate inquest is superior. Fine? You can remember police inquest is given by the section 174 CRPC. This is CRPC, not IP. This is a conducting inquest procedure, so it has to be coming under CRPC. So this is basically police inquest 174 CRPC, and magistrate inquest is given by 176 CRPC. You can remember superior. Magistrate system is superior, give higher number 176 to magistrate. Right? 174 is police inquest, 176 is magistrate inquest. Now what happens in police inquest? Let us see the procedure. What is actually happening in this police inquest? See, whenever there is a death, right, which is due to either suicide, right, or it is due to homicide, right, murder, or it is due to accident, or if the death is due to any animal, or if his death is due to under any suspicious circumstance. In all these cases, right, if the information, right, reaches the IO, right, IO will be in the police station, right. If the information reaches the IO, IO is nothing but investigating officer, also called as inquest officer, right, they call and tell that there is a murder in the particular place. That the IO will inform the magistrate, he will go to the scene of crime. And who happens to be IO? Any station officer will be the inquest officer. Who's the station officer? The station may be inspector, maybe sub-inspector. If sub-inspector is not available, it can be the minimum rank, it can be the head constable. What if head constable is not there? Can police constable be an IO? No. Head constable is a minimum rank for a person to become an IO. Right? Police constable cannot become an IO, only head constable can become IO. So this IO, he proceeds to the scene of crime, right, wherein you have dead body, right, he proceeds to the scene of crime, he conducts inquiry, right, he conducts inquiry with the witnesses, right, whatever witnesses were there, whoever witnesses were there, he conducts inquiry. Those witnesses are called as, there is a specific term for them, called as ponchas, right, the local witnesses. After the conducting inquiry, after the completion of inquiry, this IO will prepare a report. IO will prepare a report, that is inquiry report, which is called as Panchanama, right. They'll ask you what is Panchanama. That is one of your previous exam question. What is Panchanama? Panchanama is basically inquiry report, and this inquiry report will be forwarded to the magistrate, right. This inquiry report will be forwarded to the magistrate by the IO, right. If there is any foul play, if there is no foul play, he will hand over the dead body to the relatives. If there is any foul play, the dead body will be subjected for post-mortem examination, and then only the body will be released to the relatives, right. So this is the overall procedure that is happening in your police inquest, right. The IO is there, minimum rank is head constable, he proceeds to the scene of crime, conducts inquiry, that report is called as Panchanama. The report will be forwarded to the magistrate, right. What happens? See, this is given by 174 CRPC. Does the IO has got the power to summon the witnesses to police station for inquiry? Can the IO, can the police officer summon the witnesses for inquiry? Yes, the IO can summon the witnesses for the purpose of inquiry. That is given by 175 CRPC. What is that? The IO may summon witnesses to the police station, may summon witnesses for the purpose of inquiry. For the purpose of inquiry, we call, this is given by This is given by 175 CRPC. The power of IO for summoning the witness for the purpose of inquiry, that is given by 175 CRPC. That is a power of IO. That is a power of IO. Right? So I've told you 175, I've told you 170, 174 and 175. Now comes your magistrate inquest. Now comes your magistrate inquest. I told you that is given by 176 CRPC. Let's learn about that. See, I told you two types of magistrate, judicial magistrate and executive magistrate. We know that. Under what circumstances that you can conduct magistrate inquest? That is again very, very important. Right? So you can remember the EC mnemonic, you can remember C, you can remember D, and you can also remember E. C, D, E. Right? C, D, E. What is that C, D, E? C for custodial death. Right? Any death occurring in the custody, or if there is any disappearance in the custody, or if there is any rape in the custody. Right? If there is any custodial death, if there is custodial disappearance, or if there is any custodial rape, right? Basically, magistrate inquest has to be done. Magistrate inquest has to be done. But when I say custodial death, do not remember it is only the custody of police. It is not only the, we don't mean that it is only the custody of police. If any person is under the custody authorized by the police, authorized by the magistrate, authorized by the court of law. Right? In all these situations, we say it is custodial death or custodial disappearance or custodial rape, wherein the magistrate has to conduct inquest. Then D for dowry death. D for dowry death. Right? When there is suspected dowry death, we can conduct magistrate inquest. When will you suspect dowry death? Whenever there is suicide of a married female within 7 years of marriage. If a married female commits suicide within 7 years of marriage, or if there is any suspicious death of a married female within 7 years of marriage, we can say that may be suspected dowry death, wherein the magistrate has to conduct inquest. Right? And the letter E, it refers to exhumation. We know what is exhumation. It is a digging the body out of the earth. That is called exhumation. That is called exhumation. Fine. So do remember, these are the three situations wherein we can conduct magistrate inquest. We can conduct magistrate inquest, right? But here again, do remember, I told you two types of magistrate. One is judicial magistrate, another one is executive magistrate. Judicial magistrate is also there, executive magistrate is also there. But do remember, if it is custodial death, if it is custodial death, executive magistrate cannot conduct inquest. Only and only the judicial magistrate can conduct inquest. Right? When it is custodial death, the judicial magistrate only can conduct inquest. Executive magistrate cannot conduct inquest. Executive magistrate can conduct inquest only in two situations. Number one, dowry death. Number two, exhumation. What do you mean by that? Judicial magistrate can conduct inquest in all the three situations. Right? C, D, E, in all the situations. Whereas executive magistrate cannot conduct inquest in custodial death. He can conduct inquest only in two situations. Number one, suspected dowry death. Number two, it is exhumation. Right? They can ask you questions like this. Death occurring in the police custody. Lock-up death. Inquest is done by dash. They'll give you both judicial magistrate. They'll also give you executive magistrate. You need to remember it is your judicial magistrate can conduct inquest in the custodial death. Death occurring in the prison, death occurring in the lockup, death occurring in the psychiatric hospital, death occurring in the juvenile home, all these will be called as custodial death because it is a custody either given by police or by magistrate or by the court of law. Right? So do remember that. Now, I told you magistrate inquest. How can you remember all these conditions? You can remember A, B, C, D, E. What is that A? A for asylum, mental asylum, death occurring in psychiatric hospital, judicial magistrate. Magistrate inquest has to be done. Death occurring in Bostel. What is a Bostel? Bostel is juvenile home where if there is a death, you need to conduct magistrate inquest. Death in custodial, C for custodial. Custodial death or custodial rape. I told you that. Right? Again, asylum and Bostel will also be called as custodial death. This is for remembrance purpose. D for dowry death. D for dowry death. And you can also remember E for exhumation. In all these situations, we have to conduct magistrate inquest. Magistrate inquest. Fine. So do remember, I've told you police inquest. I've also told you magistrate inquest. Police inquest is given by 176. Police inquest is given by 174 CRPC, whereas magistrate inquest is given by 176 CRPC. Particularly when it is done by judicial magistrate, it is given by 176 1A CRPC. Right? Just 176 CRPC, that should be fine. Right? That is extra H, 176 1A CRPC. Fine. So let's go forward. Hi guys, now we'll be discussing on the hierarchy of criminal courts in India and the powers. This is again one of the very important productive topic in which we can get a lot of MCQs from this. So let's discuss about first the hierarchy of criminal courts. Then we'll be discussing about the powers of each court. Here we'll be excluding the civil courts from the list. We'll be discussing only the criminal courts. Right? Let's talk about hierarchy. The lowest court to start with, let us start from the base. Right? We'll start low, we'll rise. Okay. So let's start with the lowest one. The lowest court is second class judicial magistrate. Okay. So it is not executive magistrate, it's judicial magistrate, because we know that only judicial magistrate will be in the court of law, they'll conduct trial. The lowest court is second class judicial magistrate. Above them we have got first class judicial magistrate. Do remember, it is not first and second. No, the lowest one is second class magistrate, above which we have got first class magistrate. Right? You can remember like train ticket for second class, and then above which we have got first class, like that. Second class judicial magistrate, above which we have got first class judicial magistrate. Above them we have got chief judicial magistrate. And above them we have got assistant sessions court. Then we have got sessions court, high court and supreme court. Right? So this is the basic hierarchy of the criminal courts in India. Right? To start with, second class judicial magistrate, first class JM, chief judicial magistrate CJM, above which we have got assistant sessions. Then we have got sessions court, high court, supreme court. This is the entire hierarchy of the criminal courts in India. If you look at this hierarchy, you know that which is the apical court of the country, which is the apex court of the country. Do remember, the apex court of the country nationwide, right? That is Supreme Court. Supreme Court is apex court of the country, right? Which is the apex court of the state? The apex court of the state is High Court. Which is the apex court of the district? At the district level, which is the apical court? That is Sessions Court. Right? Do remember, the apex court of the state is your district is Sessions Court. For the state level, it is High Court. For the national level, it is Supreme Court. You can see that I've given different colors. All these are apical courts. You can see apical court. Apex court of the district, apex court of the state, apex court of the country. All these are apical courts. They can give any punishment given by law. Right? They can give any punishment. Right? Given by law. Not any punishment, whatever they like. It is the punishment given by law. Any punishment given by law, including death sentence. Right? Including death sentence. Remember, any punishment given by law, that is Sessions Court, High Court and Supreme Court. Right? Now, talk about the lower courts. Let's talk about lower court. You have got second class JM, first class JM, CJM and assistant sessions. In this, you can see, remember 1, 3, 7, 10. Right? Remember the number 1, 3, 7, 10. Second class, 1 year maximum punishment. First class magistrate can give a maximum punishment of 3 years. CJM can give a maximum punishment of 7 years. Assistant sessions can give a maximum punishment of 10 years. 1, 3, 7, 10. What about fine? Remember, the lowest court, that is second class magistrate, can give a fine of 5,000 rupees. The first class judicial magistrate can give a punishment up to 10,000 rupees. The remaining courts can give unlimited fine. UL means unlimited fine. They can give unlimited fine. There is no limit for that. Right? They can give 1 crore, 10 crores, 1,000 crores, right? 10,000 crores, whatever it is, unlimited fine, depending on the case. Right? So do remember, this is about the punishment, right? The fine. Second class is 5,000, first class is 10,000. Right? The remaining courts can give unlimited fine. There is no limit for that. Now you see the lowest court to give death sentence. If they ask you the lowest court to give death sentence, you can say that is Sessions Court. But do remember, there is one more court that is called Additional Sessions Court. Right? Additional Sessions Court, it is equivalent to Sessions Court. Some district you will have Sessions Court and Additional Sessions Court. Additional Sessions Court is just like additional professor. Professor, additional professor, like that sessions code, additional sessions code, where again even the additional sessions code has got equivalent power just like sessions code. But there is a difference between additional sessions code and assistant sessions code. Both are different. Don't get confused. Additional sessions code is equivalent to sessions code, but assistant sessions code is a subordinate of sessions code. Okay, so there's a difference between assistant sessions and sessions code. Now, when you look at the hierarchy, do remember these two courts, that is Supreme Court and High Court, they can be called as the courts of appeal. They are appellate courts. Primarily, they hear appeal cases, right? What about the lower courts? All the remaining lower courts, they are called as courts of trial. The trial will be primarily held in these courts. The courts, the trial, in any case, the trial will primarily be held in the remaining courts. Whereas High Court and Supreme Court, they are meant only for the appeal cases, right? Usually, they hear only appeal cases, the High Court and Supreme Court. The remaining courts, they are called as courts of trial, right? They are called as courts of trial. Do remember this. So, let's talk about certain important points to note, right? Regarding the punishment, what are the certain points that you need to note? Number one, right? Number one, commutation. Who can commute? What do you mean by commutation? Commutation means reducing the punishment. Normally, when any punishment is given by one court, who has got the power to commute? The power to commute lies with the higher court. Lies with higher court. Right? So, do remember, it's not high court, higher court, next higher court. Now, let's talk about death sentence. Let us say death sentence. Right? Death sentence. In India, the death sentence is given only for the rarest of the rare cases. Rarest of the rare cases, death sentence is given. You have various methods of judicial execution, various countries. But in India, if you talk about India, what is the method of judicial execution? What is the method of judicial execution in India? In India, do remember, it is done by hanging, judicial hanging, right? Other countries, you have other methods, right? In India, it is done by hanging, judicial hanging, right? Now, let us say, which is the lowest court to give death sentence, right? You know, it is a sessions court, right? You know, it is a sessions court. But when the sessions court has given death sentence, the person will not be executed as it is. There is a catch. Do remember, the lowest court to give death sentence is sessions court, but in all the cases, this case will be forwarded to the High Court. This case will be forwarded to High Court for confirmation. High Court for confirmation. Right? As per 366 CRPC. As per 366 CRPC, all death sentence, when it is given by sessions court, it will be forwarded to High Court for confirmation. The High Court has got the power. High Court has got the power. What can the High Court do? High Court can either confirm, yes, this person deserves death sentence, or it can cancel, it can acquit the person, right? Or it can do what is called as commutation. I told you what is commutation. Commutation means reducing the sentence. But in this case, when the death sentence is reduced, it will be converted into life imprisonment. Right? Do remember, in all the cases, the High Court has to confirm, right? Or it has to commute, right? Now, that doesn't mean sessions court cannot give death sentence. If they ask you which is the lowest court to give death sentence, your answer should always be sessions court only. Right? Which is the lowest court to give death sentence? The lowest court to issue death sentence is always sessions court. Is always sessions court. There is no doubt about that. But it will be forwarded to the High Court for confirmation. If the High Court has confirmed death sentence, who has got the power to commute? What is the next higher court? That is Supreme Court. Supreme Court has to confirm or commute. Right? Supreme Court has got the power to either confirm or commute. Right? See, all cases will be forwarded to High Court for confirmation. That is as per section 366 CRPC. The High Court has got the power to either confirm, cancel or commute. That is given by 368 CRPC. Once it is confirmed, the person has to go to Supreme Court. Only Supreme Court has got the power to confirm or commute. Now here, in case if the Supreme Court has confirmed, assuming that the Supreme Court has confirmed the death sentence, Now what to do? Now the person, the accused, has to file mercy petition. The person has to file the mercy petition to the President of India. Right? The person has to file mercy petition to the President of India. The President has got the power to commute, to pardon, to reduce the death sentence. Right? That is basically given by 72 of Indian Constitution. IC means Indian Constitution. Article 72 Indian Constitution. Not only the President, even the state governor has got the power to do it. Right? State governor has got the power to commute the death sentence, that is given by 161 Indian Constitution. Article 161 of Indian Constitution. Not only that, even that appropriate government has got the power to commute the death sentence. So all these people will have the power depending on the case. But if it is pardoning, who can pardon? Right? Pardoning of death sentence. Pardoning of death sentence. See, commutation means reducing the death sentence. Reducing the sentence. Pardoning means completely removing all the punishment. Removing the conviction, removing the punishment, that is called pardoning. This pardoning power lies only with the President of India. Right? It lies with the President of India. Right? So do remember, if they ask you, so this is the overall concept that you need to remember. What can they ask you? They can ask you, what is the lowest court to give death sentence? You know, it is Sessions Court. What is the lowest court to commute death sentence? The lowest court to commute death sentence is the High Court. Right? If the High Court has given death sentence, you need to go to Supreme Court. Supreme Court has got the power to commute. Right? So this is about commutation of death sentence. Commutation of death sentence. Do remember, in India it is done by judicial hanging. Right? The next important point that you have to remember is, see, if it is first class judicial magistrate. In metropolitan city, the first class judicial magistrate will be called as metropolitan magistrate. Metropolitan magistrate in metropolitan cities. Right? And the chief judicial magistrate, or you can say CJM, the chief judicial magistrate will be called as chief metropolitan magistrate. Chief metropolitan magistrate. Chief metropolitan magistrate. Right? So this is about metropolitan magistrate and chief metropolitan magistrate. Right? Some cases, the state government might establish what is called as FTC. What is that FTC? FTC means fast track court. Fast track court. These courts are established by the state government. It is established by the government for specific purposes, for specific cases. Right? For specific purposes. What is the power of this FTC? The FTC, the fast track court, has got equivalent power to the Sessions Court. They have got equivalent power to the Sessions Court. Right? Now in case, if any pregnant female, if any pregnant woman is given death sentence, right? If any pregnant woman has given death sentence, do remember, the High Court has got the power to postpone. High Court has got the power to postpone. Either postpone the death sentence, or it can commute the death sentence into life imprisonment. Into life imprisonment. Right? Because you cannot punish a baby for the sake of the mother as well. Right? So it will be commuted to the life imprisonment. Death sentence. The pregnant female will not be executed. Right? Will not be given death sentence. It will be commuted to life imprisonment. And who has got the power? The High Court has got the power as per 416 CRPC. Remember the section, that is important. 416 CRP. You got this question multiple times in your examination. Right? Now going forward, see, there is one more important court, that is called Juvenile Court. You call it a Juvenile Justice Board. Juvenile Justice Board. What is the Juvenile Justice Board? As the name implies, it is meant for juvenile cases. Right? Who is a juvenile? A juvenile is a person. Juvenile is a child less than 18 years of age. A juvenile is a child who has not completed 18 years of age. Right? It includes both male and female. Right? Boy and girl. Right? Fine. So it was not completed 18 years of age. If a juvenile less than 18 years committed a crime, then this person is called juvenile in conflict with law. Juvenile in conflict with law. The Juvenile Justice Board has got 3 members, right? What does the board consist of? The board consists of 3 members. Who are the 3 members? It has got first class JM, right? It has got magistrate, right, of the rank of first class judicial magistrate, preferably female, and have got 2 social workers, right? 2 social workers will be there. That is the Juvenile Justice Board, and out of this 2 social workers, one social worker must be female, definitely must be female. The first class magistrate preferably female, right? But here the social worker, one social worker should be a female, What if a juvenile has committed a crime? I told you, juvenile in conflict with law. What happens when a juvenile has committed a crime? So we'll talk about that. What is the responsibility? We'll talk about that, right? Suppose, let us say this is the age of the juvenile, right? Let us say this is 7 years. This is 12 years, right? This is 16 years, and this is 18. Above 18, the person is no more a juvenile, adult, right? So less than 7 years of age, right? The child, nothing is an offense committed by a child less than 7 years. The child is not punishable for anything. The child is not liable for anything as per section 82 Indian Penal Code. We know that. As per 82 Indian Penal Code. Suppose if the child is between above 7 years but less than 12 years, it depends on the mental maturity of the child. Where the child has got sufficient maturity to understand the nature and the consequences of the act, then it depends on the maturity of the child that is given. The punishment depends on maturity of the child, that is given by 83 IPC. This is 83. If the child is above 12 years, the child is punishable, the juvenile is punishable for a crime, but maximum punishment, it is only 3 years imprisonment, not more than that. It's only 3 years imprisonment, not more than that. Okay. If the child is above 16 years, now comes a question. If the child is above 16 years and if the child has committed an offense, then the offense will be seen whether it's a heinous crime or not. What is a heinous crime? Any offense for which the punishment is more than 7 years. Rape, murder and all. Any offense for which the punishment is more than 7 years, you can call the crime as heinous crime. Right? Heinous crime. If the juvenile is between 16 to 18 years and has committed a heinous crime, then this child will be treated as adult. Right? The child will be treated as adult. You can give punishment even more than 3 years also. Right? Any punishment can be given except death sentence. You can give any punishment except death sentence and life imprisonment. Right? If particularly when the child is between 16 to 18 years, committed a heinous crime, then you can give any punishment. Because the child is treated as an adult, you can give any punishment except death sentence and life imprisonment. If the juvenile has committed non-heinous crime between 16 to 18 years, then this case maximum punishment you can give. If it is non-heinous crime, any other crime, maybe a petty crime, right? In that case, the maximum punishment, again, it can be only 3 years imprisonment. Right? The only difference occurs when it is heinous crime and it is between 16 to 18 years. Right? Fine. So do remember, in that case, the juvenile will be treated as an adult. Right? So we have discussed about different powers of criminal code. Now we'll be discussing another important area, that is called evidence. Right? Let's talk about evidence. What is basically an evidence? What is an evidence? You might have learnt about a lot of evidence, oral evidence, documented evidence, so many evidences you might have learnt, right? And this area is nowadays becoming very important. Like you get a lot of questions in the last 2-3 years from this particular area. So you need to know in detail about evidence. So let's learn about that. Evidence is basically an oral, right? It's a statement. It is a statement or a document. It is a statement or document given or produced to establish, or you can say to prove a fact. To prove a fact. Or you can say to prove the truth. Right? Whatever may be the truth, you want to prove it. Right? Either you can give oral statement or you can produce document. So that is basically called as evidence. Right? Depending on the validity of the evidence. Remember, depending on the validity of evidence, the evidence can be classified either into direct or indirect. You can say it's a direct evidence or you can say it is indirect evidence depending on the validity of an evidence. Depending on how it is given in the court of law, you can say again there are two types. One is oral evidence, another one is documentary evidence. Right? Depending on the validity, you can say it's a direct evidence or indirect evidence. Depending on how it proves the fact, you can say that's a direct evidence or indirect evidence. Depending on how it is given, you can say that's a oral evidence or documentary evidence. Now we'll be discussing everything. Now to start with, let's start with direct evidence. What is a direct evidence? Remember, direct evidence is an evidence that directly proves a fact. It directly proves the fact. Right? Now the question is whether the accused has stabbed a person or not. Whether the accused has stabbed the victim or not, that victim, the stabbing the victim, that is a fact. How can it be directly proven? Either by an eyewitness, right? Either by an eyewitness, or it can be any CCTV footage or something where you can directly see the accused has stabbed the victim. Fine. So this is direct. It is directly proving the fact. You call it as direct evidence. What is an indirect evidence? Indirect evidence. Indirect evidence is something where it does not prove the fact directly. Does not prove directly. Does not directly prove the fact. Right? Does not directly prove the fact. You have not seen the person stabbing. Nobody has seen directly the person accused stabbing the victim. It does not prove the fact directly. But here you can see it is of two important types. Number one, you can say it is circumstantial evidence. You can say it is circumstantial evidence. This circumstantial evidence is something where you can prove that the fact is proved based on the circumstance. Based on the circumstance. Right? So based on the circumstance, you can prove the facts. So that's called circumstantial evidence. Another type of indirect evidence is there that is called hearsay evidence. You have not seen the fact. You have not seen the fact. You have not seen the crime. But somebody has told you. You heard from someone. You have heard from someone. Right? Then you become hearsay evidence. You become hearsay evidence. Right? Hearsay evidence. That is hearsay evidence where, remember, it is not valid. Hearsay evidence is usually not valid except in two situations. Right? Except in two situations. Number one, dying declaration. Right? Dying declaration. Right? The statement given by a person at the time of dying. Right? Or you can say what is called a res gestae. Right? Res gestae. Involuntary statements given by the person, right, at the time of dying. Fine. So do remember there are two exceptions. Number one, it is dying declaration. Number two, it is res gestae. Fine. I told you there is direct evidence. I told you indirect evidence under which you have got circumstantial and hearsay. Right. For explaining this, you can assume that, let us say there is a person A who was stabbing person B. A is accused, B is the victim. A is accused, B is the victim. Right. Now this was seen by the person C. At the time of incident, person C was there. He was witnessing the act of stabbing by A on B. Right. Who's accused? A. Who's the victim? B. Who saw this? C. Now after some time, at the same time, what happens? The A came out of the room. A came out of the room with the weapon in his hand, the knife in his hand, with the knife in his hand at the same day, same time, just out of the room, right? And this was seen by person D, right? C, who has seen the offense. He went to his house. He told his wife E that he has seen A stabbing B, right? Now, who are all the witnesses here? C is a witness, D is a witness, and E is a witness. You have got 3 witnesses. Who is a direct witness? Who directly proves a fact? C is a direct witness, eyewitness, who directly proves a fact, right? Who is a circumstantial witness? Who is a circumstantial evidence? This D, this person was there. He did not see A stabbing B, but he saw this person, he saw the accused coming, running out of the room with the knife, and the knife has got bloodstain on it at the same day, same time, at the time of incident, right? And D went inside the room. He could see the victim lying down with the stab injury abdomen. There were no other person inside the room. Then who happens to be the circumstantial evidence? The person D happens to be the circumstantial evidence, right? Depending on the circumstance. Who's the hearsay witness? Who's the hearsay evidence? Hearsay evidence is E, who heard from D that he has seen A stabbing B, right? So D, E, C, D, E. C will be your direct evidence, right? This will be circumstantial evidence, and E will be hearsay evidence. Fine. So these are all the evidences that we spoke about just now. Now, as I told you, depending on how it is given, we have got 2 types of evidences. One is oral evidence, another one is documentary evidence, which is more superior. See, from the name itself, you can understand oral evidence means you are giving oral evidence. Documentary evidence means you are handing over the document related to the case. That is documentary evidence. So, which is superior? Right? Many of you would tell it is documentary evidence. No, it is oral evidence that is superior. Because oral evidence you can cross-examine. You can do cross-examination. Cross-examination can be done only for oral evidence. That's why it is superior than documentary evidence. Right? Than documentary evidence. Right. Now let's talk about something about documentary evidence. What are the documentary evidence that is so relevant for medical practice? What are the documentary evidence given by the doctor? Right? Number 1, you can think of first important example is dying declaration. Dying declaration, that is one important documentary evidence. Dying declaration. Number 2, right? The medical certificates issued by the doctor. What are medical certificates? For example, sickness certificate, fitness certificate, leave certificate, right? Vaccination certificate. All these are the medical certificate issued by the doctor at the request of patient. On patient request, the doctor is giving this. This is called medical certificate, right? The doctor will also give you medico-legal reports. Medico-legal reports. What are the medico-legal reports? When a doctor is issuing autopsy certificate, postmortem certificate, wound certificate, examination of victim, accused in sexual offense. So all these are medico-legal reports. These kind of medico-legal reports are issued on the request of inquest officer, IO request, right? On the request of investigating officer. So do remember, we have got dying declaration, we have got medical certificates, we have also got medical legal reports. So these are all the different documentary evidences that are relevant to the doctor, what we are issuing to the patient and the IO, right? So I told you, do remember, I told you what is an evidence. I told you the different types of evidence, direct and indirect. Indirect, I told you 2 things. One is circumstantial, another one is hearsay. Right? Then I told you that is oral evidence and documentary evidence. I told you oral evidence is superior than documentary evidence because you can do cross-examination. Right? Fine. Let's go forward. Let us talk about next important area. We spoke about evidence. Now, what do you mean by witness? Who is a witness? Who is a witness? Right? Witness is a person. Remember, witness is a person, right, who gives statement, right, to prove the fact. Evidence is something that is produced to prove the fact. Witness is the person who gives evidence. That is the easy way, right? In simple words, right, who's a witness? Witness is a person who gives evidence. Right? Then you call that person as witness. What are the different types of witnesses? We have a lot of types of witnesses, right? Particularly what is so important for us is two important types of witnesses. Number one, common witness, right? Common witness, right? Otherwise called as fact to witness. This is so important. Fact to witness. Underline the word fact witness. You all must have known common witness, right? But do remember the word fact to witness. That is important. That will give you a lot of information. Fact witness, otherwise called as occurrence witness, right? Otherwise called as layman witness. You have lot of synonyms for this. Layman's witness, lot of synonyms for this, right? Fine. Other type of witness is expert witness. Common witness is given by 118 Indian Evidence Act. Here we are talking about IEA, that is Indian Evidence Act, because it's about evidence. And expert witness is given by 45 Indian Evidence Act. Right? Not so important, just know numbers 118 and 45. So now I told you there are two important types of witnesses. One is fact witness, another one is expert witness. Who's basically fact witness? Who can be a fact witness? Right? I told you layman's witness. Any person can be a common witness. Any person who observed the fact, who perceived the fact, or you can say who perceived the truth. If the crime is about stabbing, any person who saw the stabbing can be a common witness. Any person who observed the fact can be a common witness. Right? Now here, who can be a common witness? Right? Is there any age limit for a common witness? No. There is no age limit. That is why I told you any person, right? There is no age. Even a child can be a common witness, provided the child is able to understand, right, the question, and the child is able to answer, right? There is no age limit for this. And even an insane person can be a common witness, provided the person is able to comprehend the question and answer rationally. Not only that, even a dumb witness, a person who's dumb will be able to give evidence, the person can be a witness, the person can give evidence in the form of science, right? So do remember, there is no age limit for a common witness. Do remember, any person can be a common witness, right? Any person can be a common witness. But when this person is being a witness in the court of law, when this person gives evidence in the court of law, this person can give evidence, right, only about the fact that was perceived. Only about the facts. What do you mean by that? See, I told you, you have got C, D, E. Who can be a common witness? C, D, E. Who can be a common witness? Everybody can be a common witness. All C, D, E can be a common witness. Suppose, assuming that the D person comes to the court of law as common witness. The person D comes to the court of law as common witness. What should he say? He can only say that he has seen person A, he has come out of the room with a knife and the blood stain on it at the same time. That's all he can say. He cannot say that A has come out with a knife in his hand and the blood stain on it, so I am of the opinion that this person must have stabbed person B. Right? No. What he has perceived, he has seen only person A coming out of the room, so he should talk only the fact he was perceiving. Right? He cannot give his opinion. I am of the opinion that person A must have stabbed person B. He should not give any opinion. A common witness cannot give opinion. The common witness can tell only the fact. That is the reason why, do remember, I told you it's also called fact witness. It's only about the fact. There is no scientific opinion. There's nothing, no opinions. Now, who can give opinion? Do remember, the other type of witness is called expert witness. Who can be an expert witness? Any person who has got skill, who has got knowledge, who has got experience, right? Who has got training in a particular field, that person can be called as expert. In a particular field. bomb blast expert, fingerprint expert, toxicology expert, medico-legal expert, any person who specialize or skill experience in that particular field, you can call the person as expert. When such, see, not anybody can be an expert witness. For a common witness, any person can be a common witness. For expert witness, that person should acquire skill, knowledge, training, experience in that particular field. Then only you can call that person as expert. But when expert witness come to the court of law, this expert witness can give opinions. Right? Can give opinions on the findings observed by himself or from some other, or observed by some other person. The expert witness can give opinion, right? Expert witness can give opinion, expert witness can give interpretation. What is the example of a common witness? Common witness, the easiest example you say, that is eyewitness, common witness, right? Seen the fact, hearsay evidence, common witness. What is an example of expert witness? Expert witness, just now I told you, you have got a fingerprint expert, right? Bomb blast expert, ballistics expert, right? Toxicology expert. You have got a lot of experts. Fine. Now, the point is, who has got the first-hand knowledge about the crime? Do remember, it is not about expert witness. The common witness has got the first-hand knowledge. The first-hand knowledge about the crime, the first-hand knowledge rule applies for common witness. Do remember, this is one of your previous AIMS question, right? First-hand knowledge rule, it applies only for common witness, not for expert witness. Expert witness, right? So I've told you the basic difference between a common witness and an expert witness. You need to remember these points. It's highly, highly important, right? Now, let's talk about expert witness. I told you a person who has got expertise can be called as expert witness. What about doctor? Doctor is a common witness or expert witness. Doctor is both common witness and expert witness. Don't say doctor is only expert witness. Doctor can also be a common witness, right? Doctor is both a common witness and expert witness. Doctor plays a role of both common witness and expert witness. When you do autopsy, when you do dissection, when you do postmortem examination, you saw the findings in the body and you wrote, you documented, where you are acting as a common witness. On the basis of the finding that is available in the body, right? On the basis of the finding that is available in the body, finally you give opinion, right? The person must have died of shock and hemorrhage due to multiple injuries sustained. That is based on your expertise, that is based on your knowledge, but is based on your skill, right? There you are acting as an expert witness, right? Fine. So the doctor plays the role of both common witness and expert witness in the court of law, right? Now, when you want to give evidence in the court of law, what is the first step? Where does all start, right? You have what is called as summon, right? Also called as subpoena. Summon is also called as subpoena, right? There is a mild difference between the word, minor difference between the term summon and subpoena. But for examination, that is not for you. Just know the word, both summon and subpoena, both are synonymously used. What is basically summon? Also called as subpoena. Summon is basically a document. It's a legal document. It's a legal document issued by the presiding officer of the court, compelling the attendance of the witness. Compelling, it is compelling. Should come, right? Not requesting you to come to the court. Compelling the attendance of the witness in the court of law on a particular day and time. For what? For the purpose of giving evidence under penalty. The last word, under penalty, is again very important, right? It's a document issued by the court for your attendance in the court of law on a particular day and time for the purpose of giving evidence under penalty. This definition is important. It is comprehensive, like every word that carries so much of importance, right? Now see, I told you under penalty, right? I told you subpoena. What do you mean by subpoena? Subpoena means under penalty. That means if you have received a summon, but you have not attended the court, willful disobedience, intentionally, without informing the court, you are disobeying the summon. Willful disobedience. Willful disobedience, it is punishable. willful disobedience, it is punishable, right? And it is punishable not only for civil case, this under penalty is for both civil and criminal case, right? Civil and criminal case. Punishment may vary. They can just give warning, arrest warrant, fine, imprisonment, it can be anything. But the point is, it is punishable. Willful disobedience is punishable. That's called under penalty. Under penalty. When the presiding officer of the court issues summons, how it is delivered to the witness? How is it given to the witness? See, it is issued by the presiding officer of the court. It is delivered either through a court official or a police person, or you can say a public servant, right? Or sometimes it is delivered to a registered post. Sometimes if the person is working in a government institution, even through the head of the institution, it can be delivered to the witness. Nowadays what happens, later they are sending through WhatsApp and email also. WhatsApp and email also. But it is delivered to in all the routes, right? It delivers in all the routes. Now the point is, if suppose the person is absconding, from that area to avoid the summon, right? If I am at home only, you will give someone. No, I will lock the home and I will just run out of my home, right? So if any person is absconding to avoid the serving of someone, it is punishable. It is punishable under section 172 IPC, right? Underline the word absconding to avoid the service of someone. It is punishable under 172 IPC. Now, see, I told you that it is absconding itself is punishable. Absconding itself is punishable. Now, what happens? You have received the summon. There are two types of summon. What is that? Number one, it is subpoena ad testificandum. Testificandum. Right? What do you mean by this? The word testify. The word testify means give oral evidence. You need to testify in the court of law. You need to come to the court. You need to give oral evidence related to that case. Right? That is giving oral evidence. That is called ad testificandum. You need to give oral evidence. Right? You need to give oral evidence. There is another one that is called subpoena duces tecum. Duces tecum. What does it mean? It means that you need to produce document. You need to produce document that is related to the case. The term duces tecum, that means you shall bring it with you. While you are coming to the court, you need to bring that document. You shall bring it with you. That is called duces tecum, right? And you need to produce a document which are necessary for the trial. You have some document which is related to the case and you are required to produce it in the court of law. If you are asked to give oral evidence and you have not come to the court of law, you are disobeyed, failure, it is punishable under 174 IPC. You are asked to bring the document to the court of law and you did not bring, that failure is punishable under 175 IPC. Remember 172 IPC, 174, 175. 172 is absconding from that area, right? And 174 is not coming to the court for giving oral evidence and not producing the document, that is 175 IPC. What if suppose you get someone from two different courts at the same time, right? How should you give priority? If there is a lower court, you got a summon from the lower court and you also gotten someone from the higher court, right? Sessions court, high court. You need to attend the higher court and inform the lower court. Right? Suppose if you give someone, if you have gotten someone, one from the civil court, another one from the criminal court, you have to attend the criminal court. Suppose if you have received summons both from two courts of equal status, one from Sessions Court, another one is also from Sessions Court, you need to attend the first one that you have received. Right? First one that you have received, you need to attend that particular court and inform the other court that you will not be able to come because you have already received someone from one court. Right? You need to inform. Fine. Otherwise it is punishable. Failure, willful disobedience, that is punishable. Right? So this is about summon. But sometimes what happens, right? There is something called conduct money, or you can say conduct money. What do you mean by conduct money? You're conducting yourself to the court of law. They'll give money for that. Right? It is the money that is paid to the witness. That is paid to the witness For what? For traveling expenses, right? If you are moving from one place to another place to the court of law, you will incur some traveling allowance. The traveling allowance will be paid. That's called conduct money. You are conducting yourself. Money paid to the witness for traveling allowance, right? When will they pay? At the time of serving the summon. At the time of serving the summon. While they gives you summon, they'll give you money. That's called conduct money. In which case that it will be given? Do remember, it is given in civil cases, right? In civil cases, they'll give you conduct money at the time of giving the summon itself. But who will pay for this? The party which is calling you should pay for this. The party will pay. I told you already, civil case is between two parties, A, B. If A is calling you as his witness, the A has to pay. Party A has to pay. If B is calling you as his witness, the party B has to pay you. Right? Whichever party that is calling you, you need to pay. That party has to pay. And who will fix this amount? The court will fix the amount. Court will tell that you have to pay this much for this witness as a conduct money. But in criminal case, right, only experts are eligible for this traveling allowances. Right? Expert witness are eligible for this traveling allowances, that too after giving evidence in the court of law, right, are eligible. Fine. So remember, conduct money, that is very important, that is given at the time of serving the summon itself, paid by the party, fixed by the court of law.